Ban the Box, How to Comply with a Myriad of State and Local Laws, is being presented by Pamela Devada and Courtney Stieber. Pam is a labor and employment partner at Seyfarth Shaw in Chicago, where she leads their nationwide background screening, litigation, and compliance team. As a national authority and the firm's go-to for all issues related to the Fair Credit Reporting Act and background screening compliance, Pam participates regularly in media interviews, speeches, webinars, and training for employers. She counsels employers, resellers, consumer reporting agencies on compliance requirements under the FCRA and related state laws, develops procedures for appropriately handling national hiring needs, and regularly litigates these issues on a single plaintiff and class-wide basis. Pam has also testified before the EEOC, is a certified Lean Six Sigma Yellow Belt, and was formerly an adjunct professor of legal writing at Chicago-Kent College of Law. Courtney Stieber is a senior associate at Seyfarth in New York and is a key member of Seyfarth's background screening, litigation, and compliance team. And with that, I will hand things over to our presenters.
Thanks so much, Brian, and thanks to all of Easy Backgrounds. This is Pam Devada, and Courtney and I are thrilled to be here today to talk about a topic that many employers have really been struggling with over the last few years with regard to the Ban the Box laws. And we'll talk a little bit today about what is happening in the world and what we've seen over the last couple of years. Just as a quick get started, please understand that while Courtney and I are both lawyers, this presentation is not to be construed or considered legal advice. It's only for informational purposes on behalf of Seyfarth Shaw and presented for Easy Background. None of the information is intended to create or constitute an attorney-client relationship, and material discussed should not be construed as legal advice or counsel. We will have the opportunity to answer questions at the end of this webinar, so to the extent you do have a question, please use the question box on the GoToWebinar platform, and we will try and get to as many of those as possible. Some of them you may find that we're answering while we're going along, but we will do our very best to get to as many of those questions as we possibly can. As Brian indicated, both Courtney and I are labor and employment attorneys by trade and have a special emphasis on all things related to background screening and specifically the Fair Credit Reporting Act, as well as the use of criminal history and credit history in employment. So without further ado, we're going to go ahead and get started. On the agenda today, we're going to talk about Ban the Box, what it is, what it isn't, and talk about a little bit from a high level the EEOC history guidance and really where this stemmed from and stemmed the movement, if you will. I'm going to talk a little bit about the state law statutes, and then Courtney's going to talk about the local ordinances that are happening and that have been compiled in the last couple of years. We're then going to talk about best practices with regard to the criminal history piece, and then we're going to talk about the additional requirements that some of these Ban the Box laws have sort of added on, if you will. For those of you who've never heard the term before, Ban the Box is really another way of saying should you ban the criminal history question or the box of have you been convicted or have you been convicted of a felony or a misdemeanor, for example, on an employment application. What we saw was that back in 2012, the EEOC came out with their criminal history guidance and compliance advice on the use of arrest records and convictions. We will not go over all of the guidance today. That's really the subject of another hour or longer webinar. But what the EEOC guidance in April 26, 2012 said was that if you are going to ask about criminal history, that's likely going to be a barrier to employment, meaning that if there are people that have criminal history in their past, they may be discouraged or may not apply as their own barrier to employment because they believe that they will not be hired by the employer. So we really saw an uptick in terms of this Ban the Box movement coming back in 2012. And so the EEOC didn't prohibit it because, frankly, they didn't have the jurisdiction to do so. But they started out by saying, you know, a lot of things. But one of the main things that they said was you absolutely, it's our strong recommendation that you shouldn't ask about criminal history on the application. The other thing, just from a very high level, that the EEOC criminal history guidance said was, if you're going to use criminal history in making an employment decision, make sure that you don't use bright line rules, and make sure that you have a defense of job-related and business necessity, because in the EEOC's perspective, criminal history and the use of criminal history in making employment decisions has what's called a disparate impact or disproportionate impact on certain minority groups, specifically African American individuals, men, and Hispanic individuals. And so the EEOC came out with their guidance. It is not a statute. It is not a regulation. It does not have the full force and effect of law. However, the EEOC has had a lot of litigation and has been investigating a lot of charges when companies fail to comply with this. So what do you need to do? In addition to understanding that the EEOC is going to very much frown upon you having criminal history question on your application, ensure that you have a process by which, if you're going to ask about and or evaluate criminal history from the applicant's perspective, that you look at things like the nature and the gravity of the offense. So how serious was it? Was it a misdemeanor? Was it a felony? Was it a crime against a person or a crime against property? The nature of the job itself. What is it? What are the essential functions of the job? What does the job require? If it requires driving, a driving offense might be more job-related. If it doesn't, then you're not going to want to talk about that or potentially not consider that. And how old was the offense? And how long has the time elapsed since the conviction or the completion of that sentence? The other thing that the EEOC criminal history guidance did was it had a sea change, and it basically said, while you have to look at these three green factors coming from a case called Green versus Missouri Pacific Railroad, the other thing that you need to do is also look at a case-by-case analysis of each individual and do an individualized assessment. And for example, if you ask a question on an employment application, this is really where the ban in the box came from, you are not being able to do the individualized assessment. You're not being able to gather the information that you need, frankly, in order to make that individualized assessment of the facts and circumstances surrounding the offense or the conduct, the number of the offenses, the older age of the person at the time of the offense. Were they 22 or were they 45 and should have known better? Evidence of their prior work history. You might have that on the application, but you're not going to have a lot of these other issues like rehabilitation, character references, etc. So that's one of the main reasons why the EEOC, in their criminal history guidance, strongly recommends that you don't ask about criminal history, because they believe that it could create a disparate impact. So following the 2012 guidance that came out from the EEOC, we saw a huge movement in terms of states and local ordinances passing laws that restricted when a company or employer could ask about criminal history. Now, what we're going to be talking about today are the private employers who specifically have banned the box. Please understand that if you are a public employer, there are many other laws that come into play. And if you are a government contractor, there are also additional laws that come into play about when you can ask about criminal history. The other thing to note is that this is a ever-moving target. And these slides are updated as to what has been passed currently, but these laws are constantly, and in the past 3 years, have been really constantly been put up for bill and voted on, and now this is what we are left with. The other piece of important information that you need to know is we're talking about those laws that restrict you from asking at a certain time frame. So, for example, we're talking about laws that restrict you from asking on an application, or, for example, after an interview, or the most restrictive after a conditional offer of employment, and we're going to go through those in detail. But please understand, in addition to the items that we're going to talk about today and these state and local jurisdictions and best practices, you also need to understand that there are additional laws, state laws, that have restrictions on what you can ask, regardless of when you ask it. So, for example, in addition to what we're going to talk about today, California has a limitation on what specific information you can utilize and ask about. Many states have restrictions on whether or not you can ask about sealed, expunged, impounded, in Connecticut, erased records. In some states, petty misdemeanors or violations. We're not covering that today because that's really not on the ban the box. So if you do have a criminal history question when we talk about best practices that you decide to ask at some point in the hiring process that's legal, you're also going to want to be aware of those other laws. So with that intro, let's dive into the states before we get to the local jurisdictions and talk a little bit about some of the very recent laws that have been passed, some of which are not even in effect yet. The first one we're going to talk about is Connecticut, and that actually goes into effect January of 2017. It was initially, it was just recently passed, and it talks about the fact that employers, private employers, cannot ask about criminal history until after the initial application. We have conversations with employers all the time, and they say, well, what if I don't have the application until after conditional offer of employment? That's cause for another conversation, but what I would say is that, frankly, don't call that an application. After you've given somebody the job, they're not applying for the job anymore. And perhaps you're getting background information or other information, but that's not really an application. What these statutes are generally talking about is when you ask about the person at the beginning stages of their interest of a job, and if you call it an employment application, these laws are going to apply to you. And so there's no time limit for how long you can ask about information. So there's no limitation, for example, that says you can only ask about 7 years back, or you can ask 10 years back, etc. There is no time limit in Connecticut, but what there is that you're not allowed to ask about it on the initial application. As you'll see as we go through, many of these state and local jurisdiction ban-the-box laws have a carve-out if you are a regulated industry. So what do we mean by that? Oftentimes we mean things like if you're in the banking industry or the insurance industry, or if you are in the healthcare industry, those types of items. So is there a carve-out in Connecticut? Yes, where either a state or federal law requires you as the employer to ask about criminal history, and or if there's a security, fidelity, or equivalent bond required for the position. Now, please understand and be careful, because sometimes what we find is that you've got laws that say you can't hire certain people with certain convictions, but they don't say when you have to ask or what checks you have to run. And so if you've got two laws, so if you've got a federal law or a state law that requires you, for example, to ask about criminal history, that's what we're talking about here. But if you just have a federal or state law that says you can't hire somebody that has a specific position, in the security guard context or in the financial industry context, that's not going to preempt the fact about when you can ask about the question. And that's going to be for all of these state and local jurisdictions that we're talking about. The next state is Hawaii. And interestingly, Hawaii actually was passed prior to the EEOC criminal history guidance. It's been one of the long-standing ban-the-box laws on the book. And Hawaii has a lot of restrictions with regard to use of criminal history generally. They have a limitation on asking about or using information, criminal history information that is over 10 years old. You can't ask about it, you can't get it, you can't use it if you're an employer in Hawaii. They also have the most restrictive, and you'll see a number of these local jurisdictions, there's a handful, that have restrictions that you cannot ask about criminal history until after conditional offer of employment. And so one of the things that if you're thinking about how do we keep up with this myriad of state laws and local jurisdictions and that's ever changing, we're going to talk about this more when we get to best practices, is consider not asking about the criminal history until after a conditional offer of employment if you want a one-size-fits-all. If you do want to do that, that's the most restrictive, and certainly it's going to be likely going to hit the myriad of the different laws that we're requiring. Similarly, it also has a carve-out for federal and state laws, and so this one is a little different, which is if there is a state or federal law that requires you to consider or prohibits you from hiring an individual with certain criminal records, then you can ask about it earlier. And notice all of these laws are a little bit different, so you want to make sure that you understand when and how you can ask about the information. The next state we're going to get to is Illinois, where I'm located. I will tell you that what's interesting about all of these states and local jurisdictions in Ban the Box is we have a lot of companies come to us and say, why are we even going to ask about this criminal history? Why don't we just stop? And I'll tell you that there are some companies out there who have absolutely stopped asking about criminal history, but the majority have not. And the reason being is because while criminal history is absolutely important, it's one component. And so you can absolutely get a background check, and we would highly recommend you get background checks, but not to replace the asking. And here's why. One, oftentimes the information that a background check company can give you can only be limited to 7 years of information because there are local and state restrictions that they have to follow with regard to information that they can give to you. And number two, if you don't ask about the criminal history, you don't give the applicant an opportunity to be forthcoming, or frankly, to not be forthcoming. And so you don't get an opportunity to judge their judgment to see whether or not they were forthcoming with the information or whether they tried to hide it. And falsification is a very big issue, as we all know, if you're in the employment space and hiring or recruiting with some of our applicants. And there's been studies that through SHRM and others who have shown that the amount of resume fraud has increased exponentially in the last few years, even with background checks being conducted. So understand that. It's a good opportunity, if done correctly with the right question, that it's another opportunity for you to see if your candidate is truly the best fit for the job because they're forthcoming or not. So Illinois is the next state, and when do we want to ask that? In Illinois, it's interesting. It gives you sort of an option. If the person is going to be selected for an interview after they're selected and you tell them they're selected, then you can ask about criminal history. If you don't do any interview in Illinois, though, it has to be after post-conditional offer. So the question is, if you're going to have a one-size-fits-all, you can do it after conditional offer, especially if you're a nationwide employer. But if you're only in Illinois, for example, or only in a few states, you may want to ask people after the initial interview, and you can do that here in Illinois. It only applies to companies that have at least 15 employees. Some of these states have limitations on the number of employees. Many of them do not. If the slide has no limitation on the number of employees, then they don't have a limitation. Again, there's no time limit for how far back you can ask, although do understand in Illinois, you're not allowed to ask about impounded records. It's similar to sealed and expunged. And again, they do have a carve-out for the federal or state laws in Illinois to understand that. Going over to the East Coast, Massachusetts is very interesting. And Massachusetts is interesting because the statute says one thing, but it's interpreted a totally different way. So Massachusetts has a law that Ban the Box law specifically says you're not allowed to ask it on the initial application. But the Massachusetts Commission Against Discrimination, which is the equivalent to the state law analog of the EEOC in Massachusetts, interprets the law and that statute to mean after the first interview. It doesn't say that. That's not how the law is written, but that's how it's been interpreted. So if you're in Massachusetts, be careful about that so you understand that. The other thing is you have a restriction on what specifically you can ask about in Massachusetts. There are things known as simple misdemeanors, and certain misdemeanors over 5 years old you're not allowed to ask about at all unless you're convicted of a very specific other offense in that same 5-year time frame. And so you should get legal advice on what your question needs to say, because you do want to make sure if and when you ask about criminal history after the initial application, and frankly in Massachusetts after the first interview, you're going to ask about it, then you want to make sure you have the right question as well. There is a carve-out for the federal and state laws again, but you need to understand that if you need to know, is it a requirement that you ask about the question, or is it a requirement that you don't hire the person? The other piece of Massachusetts is that you can't ask about certain types of minor crimes as the Massachusetts legislature has deemed them. So first convictions for drunkenness, simple assault, speeding, minor traffic violations, or disturbing of the peace you cannot ask about, or prior arrests and court appearances where there was a delinquency as a child in need of services, you can't ask about. And so, Massachusetts is very, very quickly becoming one of the most regulated states in our nation, very close behind California, and frankly, it may be catching up very soon. So if you're in Massachusetts, make sure that you understand the restrictions of when and what you can ask about that. We have a lot to cover, so I'm going to go quickly through some of the other states. Some of them are very easy. Some of them have a lot more detail. Minnesota is one of the easy ones. It's very, very similar to Illinois. So it is after initial interview, and if there's no initial interview, then after conditional offer. You'll see a lot of these state laws and local jurisdiction laws are jurisdictional, meaning that, you know, depending on geographically where you are in the region of the United States, you'll see laws that are similar. So Minnesota is very similar to the Illinois law. Again, no limit on the number of employees or time limit on how far back you can ask criminal history, and there is, again, a federal and state law exception. Oh, back over to New Jersey. New Jersey, when can you ask? After the first interview. Again, it's limited to 15 employees. So if you're a small company that doesn't have 15 employees, you don't have to worry about it. Interestingly, it's likely not the number of employees in the state, although it's a little bit open to interpretation. But we would recommend, again, without giving legal advice, if you've got people that you're hiring in New Jersey, but you've got over 15 employees, even outside of the state, you're going to want to comply with the New Jersey law. It used to be that Newark, New Jersey had its own restriction, but that was preempted by the New Jersey law, and so gone is the Newark law, which was extremely burdensome and challenging to deal with, so we're happy about that. In terms of New Jersey, with depending on the crime, so certain things you can ask about and certain things you cannot. And so New Jersey, unlike the rest of the nation, doesn't have misdemeanors and felonies. It has indictable offenses and non-indictable offenses, and there's limitations for which you can ask about each of those items and what you can utilize when you're making employment decisions. So again, you're going to want to seek legal counsel, inside or outside counsel, to make sure that your question is asking the appropriate amount of information. And this one also, you'll see, has a carve-out for federal or state laws that would allow you to ask the question. Again, I caution, though, make sure that you try to comply with both of those laws and not just say, well, we're just going to throw this New Jersey law out the window. Oregon was just passed at the beginning of this year. Oregon's law, and you'll see Portland has a different law, just like Chicago has a different law than Illinois. Even though you've got state laws, you're still not being restricted from having these local jurisdictions. Oregon's law went into effect earlier this year. We haven't seen a lot of action there. We're starting to see it now. And in all of these laws, we're starting to see private, some of them have private right of actions where people can actually sue on these. Others of them have issues with regard to concerns about attorney generals coming and investigating, and so want to make sure you understand that as well. All private employers, again, after the first interview. So not on the application, but once the person has the interview. Different than Minnesota and Illinois that say once you tell the person they have the interview. This is the person actually has to have the interview. We get questions all the time of, is a phone interview enough? And it really depends on what kind of phone interview it is. If it's a screening interview, I'd argue probably not. If the person has been and is being considered for a job and they're actually having a true interview, then likely it's going to be enough. But it's really going to be a case-by-case basis. There's also a carve-out for federal or state laws that if you have to prohibit hiring someone with certain criminal convictions, again, you can ask about that a little bit earlier as well. A couple more states to cover. We're back in the New England area before we get to our local jurisdictions. The first one is Rhode Island. You can actually ask during the first interview in Rhode Island, and this is a question that comes up a lot. And the question is, should you ask during the interview? And I'm a very big proponent of not asking during the interview for a couple of reasons. One, anytime you ask the question verbally, it's going to be cause for potential risk because, number one, you're not having those other state law call-outs that you need to have. For example, don't tell me about sealed and expunged and impounded. Only tell me this in these states. Only tell me this in these states. There's so many of them, it's almost impossible to get right. Secondly, it becomes a he said, she said. If you ask about it in writing, then you have the opportunity to have a written record of that. You have the opportunity for the person to be forthcoming with all of the information that you need to do that individualized assessment that we talked about earlier. And so you have a record. You also have a record if the person chooses not to provide any information, which can be tremendously helpful. So I would certainly not recommend that you do it during the first interview. You can provide a written document during the first interview in Rhode Island. It applies if you've got at least 4 employees and there's no restriction on how far back you can ask about information, unlike, for example, Hawaii that has the 10-year. And there is a carve-out for federal and state laws if you are a regulated industry. And on our states, we've got the last state before we get to the District of Columbia and some of the cities, we've got Vermont. And so Wendy, can you ask again after the initial application? Some people say, well, what if I don't have an application? So then the question is, well, what's your process and what is your hiring process? If you've got a profile electronically, that may be different than if you have a paper document that somebody shows that they're interested in a position. So understand that all of these ban-the-box laws that we're talking about apply equally to both a paper process as well as an electronic applicant tracking process. So know that as well. You know, we're going to talk about best practices in sort of a one-size-fits-all, depending on where you may have operations. But the one thing to keep in mind as we're talking about these many, many different types of laws is, you know, the earlier you ask about the question, perhaps the more people you're going to ask, and perhaps the more people you could potentially exclude and therefore or claim to have been excluded. And then perhaps the larger amount your potential class action goes up if you're found to be violating either the EEOC Title VII of the 1964 Civil Rights Act or another law. Versus, I think of it as a big funnel, if you will. Think of your hands wide apart at the one end of the spectrum. That's how many people are in your class. And it goes down to a triangle or a funnel. The later you go in the hiring process, there's not many people you're asking. You know, oftentimes if you ask the one candidate, then your risk has been reduced. So Vermont, again, carve out for federal and state employers, no time limitation, and if you want a one-size-fits-all, as Courtney's going to discuss when we go into DC and some of our local jurisdictions here, many of these have restrictions on when you can ask based on after conditional offer. Courtney?
Thanks, Pam. So I'm going to talk about DC, which falls somewhere in between a state and a city, which is our next slide. And they're great. Okay. So in DC, you can ask about criminal conviction history after a conditional offer is made. And DC limits these inquiries for employers with 10 or more employees who are working in the District of Columbia. One question I'm anticipating is that, let's say you're an employer and you're headquartered in Alabama, which has no law, no ban-the-box law. But you have 10 employees in DC. This law would govern your business with respect to those 10 employees in DC. And the same applies across the board with any locations that have a sufficient number of employees in which these ban-the-box states are applicable, and municipalities as well. So keep that in mind when considering whether these laws apply to your company. There's no time limitations about how far back you can ask in DC, and there is a carve-out for when the state or federal law requires you to consider or prohibit an employee from being hired if there are certain criminal records in their history. There's also some consideration with respect to adverse action in DC. So for example, you need a legitimate business reason even after the conditional offer to reject an applicant. Also, there are penalties of up to $5,000 for a violation, and but there's no private cause of action in DC. If an applicant requests an explanation in DC, you have to provide them that within 30 days, and requires you to provide all the records and a statement of denial for each factor listed in the ordinance within 30 days. So it's a very specific response that's required of you. Additionally, there's some sliding scale for these penalties depending on the size of the employer, but it's up to $5,000. So there is some risk of liability there. The next city is San Francisco. And in San Francisco, again, like in Illinois and you saw in Minnesota, you ask either after the first interview or if there's no interview after the conditional offer of employment. It applies to employers doing business in San Francisco who employ 20 or more people. That means that if you have one employee in San Francisco, but you have 20 employees nationally, you are a covered employer for the purposes of this law. It limits inquiries back 7 years, so no asking about convictions older than 7 years, and that runs from the date of the sentence. And it also prohibits some inquiries about other types of the criminal background. So for example, you can't ask about or consider an arrest that didn't lead to a conviction. You can consider a pending arrest or a pending charge that's still being adjudicated at the courts. Participation, though I should note, the EEOC has guidance on how to consider such a pending arrest, and it's a gray area in this environment. You can't consider participation in a diversion or deferral of judgment program, can't consider dismissed, expunged, or invalidated convictions or juvenile convictions, and you can't consider anything that's not a felony or a misdemeanor. So for example, an infraction would be, or a violation would be something that you wouldn't be able to consider. Applicants need to get notices of their rights under the San Francisco ordinance before you can make any inquiry. And there's notice requirements, which we'll talk about more a little down the road on before taking adverse action. You have to wait 7 days for a response and provide the OLSC form, which is the notice of their rights. And there's an individualized assessment component similar to that prescribed by the EEOC. So next is Chicago. And in Chicago, again, just like with Illinois, it expands the coverage of the Illinois ban-the-box law, and it's a little bit similar. So you can ask after the initial interview, after the applicant's been notified that they're coming back for an interview, or after a conditional offer if there's no interview. It amends the Human Rights Ordinance of the City of Chicago. So what it does now is it makes the Illinois law applicable to all private employers within the City of Chicago. So where Illinois applies to people with 15 employees or more, now Chicago, if you have less than 15 employees in the city, you're still covered by the law. You can inquire after the individual has been determined qualified for the position and notified that he will be interviewed, but not before that time period. So again, that's no applications and nothing before that interview. There's a carve-out for state and federal laws, just like with the others we've been discussing. And incorporates a 9-factor individualized assessment test like the EEOC's that seems to apply to city agency hiring decisions. And then lastly, it requires that when you inform the applicant that they're going to be rejected based on their criminal history, that you identify the specific reasons why they're being rejected on that notice form. We'll get to that in a little bit as well. The next is Baltimore. And in Baltimore, this applies to any employer with 10 or more full-time employees in the city of Baltimore. It allows you to ask after a conditional offer of employment. So again, in Baltimore now you're dealing with not at the interview stage, not at the application stage, but only after they've been offered employment. It prohibits retaliation, which is a notable caveat for this law, and it does have a state or federal law exception. Again, as we've been talking about, these exceptions for laws governing state or federal law don't usually prescribe when in time you're going to be asking about criminal history, only what criminal history you should or shouldn't consider. And so that's a particular nuance to consider when determining whether or not you're going to ask at any stage before a conditional offer, and really consider whether those federal laws apply. The next one is Montgomery and Prince George's counties. So these are other Maryland statutes governing all locations within the counties of Prince George or Montgomery. And you ask after the initial interview is permitted. In Montgomery County, the law applies to employers with 15 or more full-time employees. And in Prince George, it applies to employers with 25 or more full-time employees. Both counties prohibit retaliation. They have carve-outs for federal, state, or county laws. And Prince George's County has an additional individualized assessment requirement before taking adverse action, similar to the EEOC's. They're both enforced by respective county human rights offices, and they both have this unique adverse action requirement, which again, we'll talk about in a little bit, but it asks that you identify the specific items in the criminal background check that are the reason why you're potentially considering taking adverse action, and then ultimately in your adverse action letter taking that adverse action. And it requires that you wait 7 days before taking the adverse action. And the next law is Columbia, Missouri. And you ask after the conditional offer. Again, this is one of the more restrictive time periods. It applies to all employers. It does not have a time limitation on what can be considered. It does have a carve-out for state and federal laws. It interestingly encourages an individualized assessment, but does not require it. It asks you to consider the severity and recentness of the crime and rehabilitation, duties and responsibilities of the position, and other factors before denying employment. In Buffalo, this is effective in June of 2013. It prohibits you from asking at any time during the first interview or during the first interview and during the application process, so prior to the first interview. It applies to employees of 15 or more at the location in Buffalo. And you can't, under the ordinance, you can ask if, you have a carve-out for state and federal law, so you can ask if criminal conviction is a barrier to employment under state or federal law. It does not apply if another law authorizes an inquiry or consideration of criminal history. Notably in Buffalo and in all the New York locations, you have this added caveat of Article 23A. And what Article 23A is it's a specific 8-factor test prescribed by New York law about when you can reject an applicant for employment. And it requires that you consider under 8 separate factors, for instance, the duties and responsibilities of the position, the age of the applicant at the time of the crime, the disposition, rehabilitation, and the like, and considering various factors, determining whether there's a direct relationship to the position or whether it poses an unreasonable risk to your business or your customers, for example. And this is an intensive inquiry that's specific to New York only, but it's also applicable in Buffalo. And sometimes what these ban-the-box laws do is incorporate consideration of Article 23A and making sure that that then becomes a violation of these local ordinances as well if that law is not followed, and that's what it's doing here. So Rochester, similar to Buffalo. I think we might have skipped Rochester, but I'll cover it. Rochester is very similar to Buffalo. There we go. It governs employers of 4 or more in the city of Rochester, exemption for state and federal law, and it allows a private right of action, authorizes penalties of up to $1,000 per violation, and like Buffalo, requires consideration of Article 23A. Sorry, just to go back one slide to New York City. Okay, so New York City was a big sea change, and it put into place restrictions and to ban the box but until a conditional offer of employment, but applying to employers of 4 or more. Now, the City Commission of Human Rights has interpreted that to mean if you have 1 employee in the state of New York, but you are an employer of 4 or more nationally, the law applies to you. It does not impose restrictions on the time period about what you can ask, and there is a carve-out for state and federal law, but the most restrictive piece of New York City is that it imposes a significant notice burden on employers. And what it does is it requires something called the Fair Chance Act package. So in addition to not providing or not asking the question on the application, they are actually extremely rigid about what can be said before you get to a conditional offer. So the City Commission's taken the position you cannot mention a background check in New York City. You can't say on a job posting that a background check will be required. You can't say on an application that this is subject to a background check. You cannot distribute your FCRA disclosure and authorization forms until after a background check has been, or until after a conditional offer has been given. So with all these restrictions, New York City then allows only after a conditional offer for a background check to even be discussed. And at that stage, then once you obtain the background check and you find the criminal history and that gives you cause for concern, you then have to prepare a pre-adverse action package that includes not just your pre-adverse action letter required under federal law, but also an Fair Chance Act notice form, which is available on the City Commission's website. And it goes through in detail the 8 factors required for consideration under Article 23A. And you're required to complete this for every applicant before that you're considering rescinding a job offer. So it's not even after the decision has been made, it's a preliminary step to making that decision. And then you have to share that notice with the job applicant, along with the pre-adverse action letter, along with all of the inquiries, including the background check and any other information you looked up on the applicant, and then along with the FCRA summary of rights and a copy of Article 23A, and then give the applicant 3 business days to respond from the date of their receipt. This is another complication. So how do you know when they received the form? That is something you have to consider about how you're going to mail it, whether it's going to be overnight mail or email, and how are you going to confirm that they've had that package for at least 3 business days before taking adverse action. So this is a really burdensome law and one that is a real sea change in New York.
And we'd highly recommend that you get advice or counsel if you're in New York City, especially or before trying to deal with the New York City Fair Chance Act, because it really, as Courtney said, it is a sea change and it's tremendously burdensome. We're going to move down a little bit and go over to Philadelphia, and we'll go through the rest of these and then get to best practices and have some time for questions.
Yeah, so in Philadelphia, this has actually been updated last year. Philadelphia is one of the first ban-the-box laws passed in 2011, but the City Council has updated it to be more strict. So where it used to apply to employers of 10 or more employees, it now applies if you have just 1. It used to be after the initial interview you could ask. Now you have to ask after a conditional offer. It limits inquiries to 7 years. It does still have its carve out for state and federal law, but it has added an individualized assessment process and consideration, and it's also added an adverse action process in which you have to notify the applicant in writing the basis for the decision and give 10 days for a response. Next is Portland. And in Portland, you have, and can we get the next slide? Thanks. In Portland, it's effective January 1 of this year. It's new. Portland prohibits inquiries until after a conditional offer. It's stricter than Oregon, which requires you wait until the initial interview. So this is a little narrow nuance for Portland, the city itself. It applies to employers with 6 or more employees, at least one of whom is in Portland. So again, you have that distinction of total employees versus the number in the city of Portland. So you have 1, it applies. There's no time limitation. There is a carve-out for federal and state laws. It also requires an individualized assessment, so your conditional offer can only be revoked if your criminal history has a direct relationship to the position and you demonstrate business necessity. Going on to Seattle. Seattle's been around for a while, November of 2013. It applies to anyone with 1 or more employees in Seattle, so that's all. you cannot consider crimes older than 10 years. That's in accordance with Washington law. And you can ask after the employer has completed its initial screening of applicants to eliminate unqualified applicants. And so that's an interesting nuanced definition. It implies that it's after your initial review of the application. Best practices would probably be to wait a little bit longer than that. You have the carve-out for federal and state law, and applicants may exclude, notably, they may exclude certain criminal history when they disclose criminal history that's been the subject of a certificate of rehabilitation or other equivalent procedure. That's a finding of rehabilitation, and that should not be considered. You have to wait 2 business days after informing the applicant with your pre-adverse letter before taking action based on the criminal history. Next is Austin. This is really recent, April of 2016. It restricts inquiries to after a conditional offer and applies to anyone of 15 or more employees. Notably, employer includes any agency acting on behalf of an employer, which would include third parties and possibly staffing agencies. It requires an individualized assessment in Austin, which is very similar to the EEOC's guidance before you determine the candidate to be unsuitable for the job. There is a carve-out for federal and state laws. There's no private right of action. It's enforced through a local organization or agency called the Equal Employment Fair Housing Office, and they have represented that civil penalties, while they will be available under this law, will not be enforced or imposed until 1 year after it's effective, which is April of 2017. All right, I think that's all the cities.
So now you've seen the myriad, truly, of the different local jurisdictions and state laws. Thanks, Courtney, for going through those. They're very, very detailed in many instances. And so what's an employer to do, and what's sort of the takeaways? So we want to spend the last bit of time we have here before we open it up to questions. And if you do have questions, please make sure you answer those, or excuse me, ask those in the question box. But what are some best practices, do's and don'ts? So first of all, if you want a one-size-fits-all, wait until after conditional offer, unless you are mandated for doing so prior to that. And most regulated companies are actually not mandated. They're mandated from not hiring somebody, but not giving them a conditional offer. It's going to reduce your risk. It's going to be less individual. It's going to be less burdensome, and it likely is going to comply and comport with all of the EEO requirements, state laws, and local jurisdictions. Arrest records. Consider not asking arrest records, which does not result in a conviction. Many of the states that we've been, local jurisdictions that we've talked about, have restrictions on arrest records. The EEOC believes that arrest records are per se acts of discrimination, and because it's innocent until proven guilty. Don't ask about sealed, expunged, restricted, juvenile, pardoned, impounded, erased records. All of those things in the myriad of different states are restricted, so be very, very careful about that. And frankly, if something is expunged or sealed, or was it happened when the person was a juvenile and they weren't convicted as an adult, you don't want to know about it because it likely is not going to be job related. What are some things that you should consider doing? Well, 1, consider asking about the question. 2, consider conducting a job relatedness inquiry. If you don't care about certain crimes, perhaps don't ask them. You know, you can only ask about felony convictions, or you could choose to only ask about misdemeanors. You could choose to only ask about things that are related to theft, fraud, and violence. Be a little careful with that because your opinion of what theft, fraud, and violence may be very different than somebody else's. But again, if you only ask the person that is potentially being hired, or a couple of people who you're considering for the job, you actually want that person. You're not trying to use this out as a weeding tool. You're utilizing the criminal history question to ensure that it's really, truly job-related and that this person is the best fit for the job. Consider having a centralized screening role who will look at the background check and the criminal history questionnaire, if you will. We recommend doing a post-conditional offer criminal history questionnaire that allows the person to not only give the information regarding the crime, but also to give all that information that you need for the individualized assessment. So tell me about, the facts and circumstances. Tell me about any rehabilitation. Tell me about how old you were at the time of the offense. And we actually strongly recommend putting those bullet points out and specifically listing them so someone can actually respond to them. Absolutely review your policies, your procedures, your applications. If you have not had your employment application reviewed, make sure you do. We hear oftentimes from companies, Courtney and I get this all the time, of, oh, well, I just printed out my paper applications and so I have to use them up. If you are utilizing paper applications, make sure that you get them reviewed and pushed out and all the other ones get thrown away, lest you become the inquiry of a private litigation action or an attorney general action. Similarly with applicant tracking systems, make sure you talk to your applicant tracking systems and know what is being asked as well. And the last topic we're going to talk about before we get into the area of questions is some of the additional requirements. And Courtney actually already teed most of these up when she was talking about all of the specific restrictions and in terms of these different jurisdictions. But the key is, what happened was, in addition to the ban-the-box laws, what some of these ban-the-box laws did was, instead of just taking out criminal history, they specifically said that you have to put certain information in the before taking action on the criminal record, solely on the criminal record, you have to hold the job open and you have to identify the specific records. Most companies are not doing that because these are brand new laws. San Francisco went into effect last year, as well as Seattle. Similarly, with Prince George's County and Montgomery County in Maryland, both of these jurisdictions require that your pre-adverse action letter has a requirement of what you are taking action on. And why does this matter? Well, it matters if you're outsourcing your adverse action process. It matters if the person who's sending these letters and compiling these letters doesn't know that these additional requirements are at play. So you need to make sure that you understand that as well. And you'll see the remainder of these jurisdictions also do that as well. So again, Chicago. Now, interestingly, in Chicago, it's not the pre-adverse action letter that has to have the basis for the purported decision. It's the adverse action letter. If you're in any of these jurisdictions, we strongly recommend that you know what they are and you make sure that you change the pre or the post-adverse action so that you can understand that. Philadelphia, again, the same thing, the basis for the notice of the decision, but also, and this is a big one, like New York City that we talked about in detail, you now have to wait 10 days for a response for the individual to provide that information. For Portland, Oregon, same thing, adverse action. It's not 100% clear if this is going to be required, but it seems like from the language of the statute, so we're certainly recommending it and wanting to cover it. Similarly, Austin, Texas is a brand new one with the adverse action information of the criminal history. And then last but not least, and we won't belabor it too much, but New York City and New York State, as Courtney has been living and breathing. Courtney is in our New York office and is a resident expert on all things New York and New York City, and she and I have been dealing with this now for a number of years. New York Article 23A is not new. It was sort of reissued, if you will, back in 2009 because nobody's paying attention to it. But the key is there are a lot of tremendously burdensome specific requirements that you must have a process to comply with, and if not, the New York City Civil Rights Commission, there will be ripe for a claim, and they're looking for these all over the place. Any acknowledgement or any notification, as Courtney stated earlier, in your disclosure and authorization forms for background checks that talk about, for example, information of a background check, but that's done before a conditional offer. May be an inquiry or statement of the information. And this keeping the job open for 3 days is tremendously burdensome. So with that, we've got about 5 minutes left, and we will open it up to questions. We're going to turn it over to Brian so that we can field some of the questions. If you do have them, please go ahead and put them in the question block on the GoToWebinar. Brian?
Yes, thank you, Pamela and Courtney. Certainly, if you do have another question, please go ahead and submit it. And now we will begin to answer some of the questions. So without further ado, question number 1. What is the best approach for a company that has headquarters in a state with no ban-in-the-box laws, but may have locations in states where ban-in-the-box laws do exist?
Yeah, I mean, I think if you have locations, then you want to do the most restrictive, or else you have multiple applications, but that in this day and age is tremendously burdensome. So most restrictive law where you're going to be having individuals hired is what we would recommend.
Okay. And question number 2, which may be somewhat similar to the previous question, but I will throw it out there. Let's say we are a corporation located in New Hampshire, but are hiring employees in other states like Massachusetts or Connecticut. Do those state laws still apply? I can't remember if there were a number of employees rule.
Great question. And so the answer is it's going to apply to the people who are potentially living or working in those states. So you may be located in New Hampshire, but if the person is living in Massachusetts or potentially will be working in Massachusetts, we strongly recommend that you comply with Massachusetts law. New York City, Courtney and I have had experience where perhaps even if you're not in the city proper, you're living somewhere outside, but you're applying for a job in New York City, do you have jurisdiction, and does that New York City law potentially apply? And so the answer is wherever the person lives and or will be applying for the job, you should apply the most restrictive law in that jurisdiction. So in that situation, in the example, Massachusetts and Connecticut law, if the person lived or worked in either of those, I would apply those.
Okay, thank you, Pamela. Question number 3, to clarify, when you say ask on when we talk to an employee, do you mean when we tell them that we run standard background checks? Would you have any issues with that?
So the one thing I would say is what we're talking about is when you ask about criminal history. But Courtney, you want to talk a little bit about New York City and the quote-unquote ask issue real quick in terms of the inquiry?
So in New York City, the rule in New York City is a little complicated because the statute prohibits you from mentioning that a conviction or a criminal background check will be conducted. So you wouldn't want in New York City to tell them that you run standard background checks because that could be a possible violation of the Fair Chance Act. So our or even distributing your FCRA forms at any time in the hiring process before a conditional offer is a potential violation because it could be deemed to be requesting criminal history from that applicant. So we recommend, when we say ask, depending on the location, we're talking about asking employees, either to disclose their criminal history or in New York City, for example, to provide a disclosure and authorization form or even mentioning the background check.
Whether it's verbally asking or asking on a piece of paper or asking by the disclosure and authorization form, at least in New York City, that's what we're talking about. I think we have time for 1 or 2 more if we have any.
Okay, we do have 2 more here. The next one is, what are the laws, specific ban-in-the-box laws in New Orleans, Louisiana?
There's not a private employer ban-in-the-box law in New Orleans.
And the last question, what constitutes a conditional offer?
Yeah, that's actually a really good question, and there's not a lot of interpretation of the law on this. And so people ask often, is it a verbal offer? Is it a written offer? We recommend generally that you have, for example, if you give a verbal offer and you get an acceptance, or you give a verbal offer and you confirm it with an offer letter, an offer letter would be a conditional offer of employment. And in that offer letter, you can say, attached, here's your offer. Attached, please find a criminal history questionnaire that has all the bells and whistles and caveats we've talked about with the different state issues of what you're allowed to ask and not. That's post-conditional offer. It could be a verbal offer also, but then it's going to be hard to prove it up. So you want to make sure that you paper that.
Okay, great. Well, I think that wraps up all of the questions that were there. Was there anything else, Pamela or Courtney, that you guys wanted to add there?
Nope, just thanks very much for the opportunity. We certainly appreciate being here on behalf of Easy Backgrounds, and appreciate everybody attending the webinar today.
Okay, well, thank you guys very much, Pam and Courtney, and thank you to everyone who attended and joining us. Hopefully you gained some valuable insights. If you do have any questions regarding background screening or this particular webinar, we will be sending out an email with information on who you can ask some questions to on the Easy Background side, and you will be receiving that email hopefully within the next day or so. So thank you, everyone. Have a great day.
Thanks, everyone.